Court does call the case of the People versus James Whitley.
Defense lawyer calls for emergency hearing to discuss bond and other issues. It doesn't go well, and Judge Simpson makes the right decision and ends it the best way possible. Make sure to watch to the end. Let me know in the comments if you agree with the judge.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and on behalf of James Dennis Whitley.
This is People's emergency motion to modify bond in this case.
Your Honor,
Yes, sir.
I didn't file a response because we got this at noon yesterday, but honestly, we also yesterday afternoon received a discovery which we've gone over. There's some issues that I certainly have with the allegations contained in the People's motion. The simplest one is under paragraph 8. It lists 4 offenses: criminal history, A and B, the same offense. 22821 is a district court case that became a felony, was found over reporting registered actions, resulted in a plea to operating law for a second offense, 31621. So that is one, that's the minor issue I have. Their description of what happened on this date contains, I think, some confusing statements. Paragraph 3, they say that the children saw the witness the assault, but in paragraph 5, they correctly state the 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10, mom says she was 11. Said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant has looked in a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When he first asked whether or not he strangled her, she said, I will tell you that I will say that if you tell me I have to. This is not the case that they purported to be. This case is more consistent with what I explained as Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
This Fink, did I say Mr.?
You said
Judge Magistrate Fink, I'm sorry. You're all your honors to me. So. I don't want to get too much into the case, but what I will say is there are a huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. What's also not contained in the report is the report says that she called, the alleged victim called the police, and actually that her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years, and her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He always has a smile on his face. Stunned that it happened. The children said, don't hear him argue, never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. we look at the factor of the likely sentence. This, I initially had scored it as 0-17, but then when I looked at his record, more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanction. It's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relationship. B2, 0 to 11 months probation. And the people are asking, not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to at trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that would be used in a felony. Guideline scoring, off or operating while intoxicated. It's always showed up. The only history of substance use or addiction is what is related to alcohol use. Certainly, he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous. Also, what I just said relates to the seriousness of the offense, presence, or absence of threats. And Wilson's trauma mentally. He has had no contact with her since this incident happened. He has been exceedingly proactive. My legal assistant has been in contact with the officer in charge since this happened. The day that it was indicated that the complaint was authorized, she tried to turn him in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification that she shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He is employed, he works 50 hours a week with daily infrastructure. He just told me that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here. His job's here. He has no ties to any other community. As I said, as far as the other thing, he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love him. I love all of these things. This is my fault. You only send a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open from something that she threw at him, most likely a phone based on her statement to the police. That happened before these other things.
Go ahead.
She denied being strangled. She said that her head hurt, not because of an injury, but because she was confused. Quite honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's an upstanding citizen of Washington County. The prosecutor's office is seeking to punish him by $150,000 bond. It has nothing to do with what her allegations were at the time and nothing with what really happened. I don't see in here, I've only had, 27 hours to look at this stuff. The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. What it does just come down to, Your Honor, is Mr. Whitley is not dangerous. He's going to show up. And he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of daughters. The mother has it. She's never made allegations of domestic violence in the past because it didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you she doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write. She just wrote. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, 1 for the chest and 1 for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of her intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count 1 on here is charged in the alternative of assault, GBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault, GBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I'll make it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions, some of the issues that she had. Her
What does
children,
that mean?
her children, and she said this had never happened before by Mr. Whitney. Never happened before. Okay.
But I don't understand the first part of what you just said,
Well,
and how that relates to this.
She may have some PTSD related to the trauma before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
the prosecutor is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying.
Okay.
And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off the bed. I don't know. I don't know what she's going to say in the statement. And what's important about this, no influence whatsoever by Mr. Whitney. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Right. RTA District Court for County, Washington, session beyond the J.
You may be seated. Court recalls the case of the People versus Whitman.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Lisbon on behalf of Mr. Woodley, who's standing to my right. Mr. Woodley, can you state your name before, please? James Dennis.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right.
Rough ending. I would have loved to been a fly on the wall when the defendant asks why he is paying this guy. It certainly didn't go well. May 10th at noon. We will be there. Will you?